To the ACLU. My name is Nate Fried-Wessler. I'm a staff attorney with the ACLU Speech, Privacy, and Technology Project. And we're here in the ACLU offices. You can see we're busy fighting for constitutional rights. We're here to talk about your rights at the border and other ports of entry. That's airports, land border crossings, seaports if you're coming in on a cruise, and what you can expect there, what your rights are. There are a lot of important questions that we hope to be able to answer, and so please send us your questions. I'm joined here by Aisha Bandari, a staff attorney in the Speech, Privacy, and Technology Project here at the ACLU, and Hugh Handyside, a staff attorney with the National Security Project here at the ACLU. The three of us have worked on these issues for a long time. These are not issues that are new under the Trump administration. They go back, but the concerns are heightened now for obvious reasons as we try to figure out what our rights are under this administration, what our rights are under the Constitution, and how to protect them. So please send us your questions. We want to have a conversation. We want to be helpful. We want to shed whatever light we can on how we can best protect ourselves when we're at the border, whether we're talking about searches of electronic devices or what to do when a customs agent asks for a password to your phone or your laptop, whether we're talking about what kind of questions are proper for a border agent to ask you, whether they can ask about religious practice or about what you were doing on your trip abroad or about your friends or associations or family members. How long can you be detained at the border? What kind of treatment can you expect? These are all really important questions that Americans and visitors to the country encounter all the time crossing our borders, and we want to make sure that people are armed with the most accurate information possible. Before we get started, we have a lot of materials on the ACLU website that are helpful in this area, including a Know Your Rights guide with answers to a lot of the frequently asked questions in this area. You can get there by going to www.aclu.org/airports. Lots of good answers there, as well as a form where you can submit accounts of experiences you've had at the border that you think may have violated your rights. And it provides us with a way to get a sense of what's happening out there and to potentially help take action in particularly bad situations. So let's start our conversation. Aisha, do you want to get us started talking about what people's rights are when they're traveling into the U.S., whether it's crossing from Mexico or Canada or flying into an airport with an electronic device, with a smartphone or a laptop or a flash drive, things that all of us carry with us in our daily lives, including when we travel. What can you do if a border agent wants to search that?
Sure. So the most important thing to know is, in the first instance, the government claims the authority to search travelers' electronic devices when they are at the border. There is a policy dating from 2009 in which the government reserves this right to do so even if there's no individualized suspicion. And the law is murky. The state of the law at the moment is unclear because the Supreme Court has not definitively ruled on whether the Fourth Amendment requires individualized suspicion or a warrant before an electronic device is searched at the border. So with that said, there are certain things that you should know, certain rights that you can assert, and then choices that you may want to make based on your own personal circumstances. In the first place, your right to refuse to turn over a password to an electronic device will depend on your citizenship and immigration status. U.S. citizens and returning green card holders should not be refused entry into the country for refusing to turn over a password to an electronic device. That said, you may have your device seized by the government and potentially held for weeks or months while the government searches the device. And you may be detained for up to several hours if you do refuse to hand over a password. So these are just things you should know, and as you decide what you want to do if you are asked for a password. And if you are not a green card holder or a citizen, if you are a visitor from a visa waiver country or someone traveling with a visa, you do risk being denied entry for refusing to hand over a password, so be aware of that. Now, there are some things you can do to protect yourself in advance of a trip. Obviously, you can travel data light. If there is information that you do not need to be carrying on your devices, you don't need to carry that information. You don't need to bring devices with you that are unnecessary. You can also make sure to encrypt all of your devices and shut them down when crossing the border. Make sure that everything you have is locked with a strong and unique password. And use cloud services. Upload your data to cloud storage services to the extent possible, and don't carry them on you. If you have photos on a digital camera, for example, you can upload those to a USB key or to a cloud storage service and reformat the memory card on your camera. These are just some of the steps you can take. We're happy to talk more and take your specific questions.
Thanks, Aisha. So that deals with one thing that can happen at the border, right? You're carrying all this information with you in your pocket or in your bag that you may, for very legitimate reasons, not want to share with the government, right? Information about your communications with loved ones, your text messages or emails, intimate photographs, medical information. Then there's another category of information that's not in your pocket or in your bag, but is in your head. Things that equally, we may want to protect from government scrutiny, not because we have something bad to hide, but because it's really an aspect of protecting our constitutional freedoms. So, Hugh, can you talk about what kinds of questions are appropriate for a border agent to ask somebody, and what people can do? What are your rights when you're trying to decide how to respond to questions?
Sure. There's no question that the government has the authority to stop travelers when they're seeking to enter the country, and they can stop them for a reasonable period, question them about the purpose of their travel, and search their belongings and their persons if necessary. And they can do that without any suspicion that that particular traveler has engaged in any kind of wrongdoing. What they can't do is refer you for secondary inspection or for additional screening based solely on your race or ethnicity or apparent religion or other kind of protected characteristics like that. We have heard of instances in which Customs and Border Protection officers have asked particular travelers about their personal beliefs, specifically their religious beliefs, and on occasion about their political beliefs. And typically the target of those kinds of questions have been Muslims, almost exclusively Muslims. And those Muslim travelers have been asked about what sort of, which kind of Islam they practice, whether they're Sunni or Shiite, whether or not they go to mosque regularly, who their imam is, other kinds of specific questions about their religious beliefs. Those questions go to the very heart of people's First Amendment rights. Our beliefs, our religious beliefs and practices are protected under the First Amendment, and we don't surrender those rights when we cross the border. So travelers should feel free to decline to answer those kinds of questions. And if the officers persist, you can always ask to speak to a supervisor, but you can make it very clear that you don't think that line of questioning is appropriate, and that you'll refuse to or decline politely to answer those kinds of questions. And then, of course, we're very interested in hearing about those instances. So, as Nate mentioned, it would be great if that happens, you go to the ACLU website and provide an account of that kind of questioning and submit it to us.
And if you go to aclu.org/airports, there's a link to a form you can use to let us know what happened.
And just one other issue that we see, aside from the device searches or the questioning, is just unreasonable detention. As I mentioned, the government can detain you for a reasonable period, but U.S. citizens have an absolute right to enter the country, and green card holders also have a right that's grounded in the Constitution to re-enter the country. So at some point, what is a lawful border detention will become an unlawful seizure. It's not clear when that happens. There's no bright line rule as to how many hours they can hold you. But we are very interested, of course, in hearing about multi-hour detentions, particularly when there doesn't seem to be any valid purpose based in any kind of suspicion about you or what you might be carrying. And so if that happens, that's another reason to get back in touch with us.
Right, so we're starting to get some questions, and I want to turn to those. But again, my name is Nate Wessler. I'm here with Aisha Bandari and Hugh Handyside from the ACLU, talking about your rights at the border. What are your rights? What can border agents ask you? What can they search? How can you respond? So Jim asks, Aisha, I think this is a question for you. My understanding is that it does not matter if you're an immigrant or a U.S. citizen. They have the right to search your phone. Is that not correct?
So, to be clear, the government at the moment asserts the right to search electronic devices regardless of whether you are a citizen or an immigrant. And the courts have not definitively weighed in on whether more individualized suspicion is required, whether it's probable cause, whether it's a warrant. At the moment, the government says we can search your devices regardless of any level of suspicion, regardless of whether you're a citizen or an immigrant. That's something that you should all be aware of. As I mentioned before, one of the questions that might arise is, are you required to give up your password? And that's where immigration status can make a difference, and where citizens and returning green card holders shouldn't be denied entry if they refuse to hand over a password. Nonetheless, if your device is seized, the government may either do what we would call sort of an on-the-spot manual search of the things on your phone, whether that's your applications, email, social media apps, texts, contact lists, or they may keep the phone to do a later forensic search. And forensic searches can be very invasive. It's important to know that if the government, in fact, has your device and does a forensic search, they can get deleted files that you weren't even aware were still on the device, metadata, all other files that are currently on the device. It's essentially a computer strip search. So be aware when you're carrying devices of that risk. And as I mentioned, you may want to consider taking steps to minimize the data you carry for that reason.
And we should be clear, this is an issue that's been going on for a long time, and something that the ACLU is very deeply concerned about. And we've been working for years to push back against this expansive, really offensive claim of authority. So as early as 2010 and 2011, we were filing lawsuits against the government, challenging their authority, their claimed authority, under the Fourth Amendment to search people's electronic devices with no individualized suspicion whatsoever. We've sued under the Freedom of Information Act to get records, so we have basic information about who's being searched, how many are U.S. citizens, how many are visitors or green card holders or visa holders. Just recently, we filed a friend of the court brief in a federal appeals court in a case out of Virginia, making these arguments about why, in fact, under the Fourth Amendment, a warrant should be required. So we're pushing back where we can, but as a practical matter, a lot of the time, people should be aware of the situation you may be in and the choices you have to make at the border. So I want to turn to another question. This is from Bill, who's asking about, really what is the border, and is asking, isn't there this concept of a 100-mile zone of the border where the government claims broader authority or has broader powers to search you? Aisha, should people be worried about device searches within that 100-mile zone once you've gotten through the airport or cleared the border crossing at the southern or northern border? What are the real concerns there?
Yes, this 100-mile zone issue is something that we've certainly pushed back against, and for people living in border communities is a real problem with checkpoints and immigration stops. But just to be clear, when we're talking about the government's asserted authority to search electronic devices, we really are just talking about when you are at the border entering, whether it's a land border, at an airport, or a seaport. We have not heard of any instances of the government within 100 miles of a border simply stopping people and searching electronic devices. That shouldn't be happening, and if that is happening, we definitely want to know about it. There are some sort of complicated exceptions of when a border search might continue beyond the point that you've left an airport if, in effect, it hasn't ended. But if you have left an airport, you have gone home, you've gone about your business, there should be no reason that the government should come and ask to search your device without a warrant. And you should feel confident in that. And certainly if you hear of that happening or it happens to you, we definitely want to know about it. As Nate mentioned, aclu.org/airports is where you can go, and there's a form there. You can give us information.
So Rinku asks, what are they looking for when they're doing these searches? Hugh, can you talk a little bit about the kinds of investigations that are happening at the border? Well,
typically for a long time it was drugs or other forms of contraband. And some of the authority that has grown up around that objective has been specifically oriented to it. So if they want to conduct a strip search, they need to have an elevated level of suspicion, specifically that you're carrying some kind of contraband, and in most cases that's been drugs. So they have to have a strong enough reason to believe that you're actually hiding drugs on your person. They can't conduct a strip search just because they think that you may have been involved in some sort of illegal activity somewhere else in the world. So it's typically drugs, and part of the argument that we have with the government is that it wants to define its mandate at the border very broadly. It wants to say we're looking for really anybody who's up to kind of no good, and we want to define the mandate more narrowly, consistently with their the authority that they have grounded in statutes by law. and typically they're trying to determine if people are admissible to the United States and whether or not they're bringing in any kind of contraband. And typically their questions and their searches should be oriented around those two objectives. And for U.S. citizens, there should be no question about your admissibility. That question has been answered. And so really it comes down to whether or not you're bringing in any contraband. And to the extent that they're searching or they're asking questions, it should be focused on that.
So to folks who have just joined us, we're here at the ACLU. I'm Nate Wessler, here with Aisha Bandari and Hugh Handyside, talking about what your rights are at the border. Steph asks, most legal searches require a warrant, don't they? And that's absolutely right. Normally, when you encounter law enforcement, local police, the FBI, the DEA, inside the country, in order to search a private space or a thing or a place in which people have a reasonable expectation of privacy under the Fourth Amendment, a warrant is required. That means go to a judge, show probable cause, and then get a piece of paper, a warrant that authorizes a search and explains exactly what can be searched and what the limits are on that search. The border has always had a different rule, but really the fight that is starting to happen in the courts and that we are pushing hard on is to figure out how this old different rule at the border that says no warrant is required should apply to these kinds of digital devices that are nothing like a suitcase or a pocketbook that might have had drugs in it in the past coming across the border. Now we're talking about all of our communications, all of our photographs, all of our medical records, all of our very sensitive records, more than we ever could have carried with us before. Aisha, can you talk about the arguments we made in our most recent Friend of the Court brief on this issue?
Sure. And I want to be clear, sometimes you hear people saying, well, the Fourth Amendment doesn't apply at the border. That's not true. The Fourth Amendment applies. We have constitutional rights at the border. The question is just, what is the scope of the historic exception to the Fourth Amendment's warrant requirement? And typically, for routine border searches, the courts have held that customs agents do not need a warrant for searches of luggage, for example, things that people are transporting across the border. But what we've argued most recently in the Fourth Circuit Court of Appeals, based out of Virginia, is that for electronic device searches, these are searches that are so invasive and where our privacy interests are so great that the Fourth Amendment's warrant requirement should apply. And these shouldn't be considered routine border searches which don't require any individualized suspicion whatsoever. And the Supreme Court, in a decision called Riley a few years ago, made this clear, when it talked about what's known as a search incident to arrest. And it said that typically, while officers who arrest someone may not need a warrant for particular searches of the person they do after arrest, they need a warrant to search their electronic devices, because the digital data contained on those is so invasive and the privacy interests are so great that that's what the Fourth Amendment requires. And we are arguing the same is true at the border, that even if routine border searches of luggage can go forward without a warrant and that's consistent with the Fourth Amendment, that's not true of electronic devices. And it's apparent even thinking about the things that we have on our phones that even a quick search could reveal. Social media apps, email, text messages, entire contact lists, all of your personal photos. There's just so much that's available there that that a warrant is the only real protection consistent with the Fourth Amendment.
So Rinku asks, if you're detained, do you have a right to a lawyer? Hugh, what can you reasonably expect if you're in that secondary inspection room, waiting for more questions?
Right. Well, U.S. citizens do have a right to a lawyer. The precise scope of that right when you're at the border is not quite clear. But it is clear that if the questioning goes beyond what you would expect to be quite routine, questions about what you did when you were out overseas or the purpose of your travel, and the questioning transitions into something that feels more accusatory or suggests that you may be suspected of some sort of wrongdoing, certainly you are entitled to counsel in that situation, and you have every right to assert that right. The same should go for green card holders as well. But the same probably does not apply for non-citizen visa holders. So in that situation, again, unless there is a strong indication that you're being accused of a crime and that your statements could incriminate you, you probably don't have a constitutional right to counsel. You can always assert your right to remain silent.
And this is a kind of related question from Chris. If you're a citizen or a green card holder, are you allowed to take notes during that encounter and secondary inspection when you're at the border?
Certainly, and it would probably be advisable. And if there's anything problematic about the search, I would definitely recommend getting the name of the CBP officer who's conducting it, trying to get the name of the supervisor who's involved, getting any other kind of identifying information like badge numbers, and if anything of yours is taken, get a receipt for that. Document it as much as you possibly can, and we're always interested in hearing those kinds of details. And to the extent that there's any following action, it doesn't have to be a lawsuit. It could be an administrative complaint to the Department of Homeland Security. It could be other sorts of actions for redress that fall short of a lawsuit. That kind of documentation will, of course, be helpful.
So Jim asks, does putting a device in your checked bag make a difference? And Michelle is wondering, do you have to turn over all your electronic devices, even a USB drive? HR, can you talk about those kind of questions?
Yeah, the question is, does it matter where you're carrying your device? The most important thing is you shouldn't lie to any government agent at the border. If you are asked if you are carrying a cell phone, you have to tell the truth, whether that cell phone is in your purse, you're holding it, whether it's in your checked luggage. So it'll really depend on the questions that the agents ask you. It may be that they're not interested in devices in your checked luggage. It may be that they are, and they ask you about those. So it's really hard to say in advance. Certainly, you can carry whatever devices you carry and have them locked and shut down. You may be asked to turn them on. So there's no hard and fast rule on that.
So again, we're here at the ACLU. I'm Nate Wessler. I'm here with Aisha Bandari and Hugh Handyside, talking about what your rights are at the border when it comes to device searches or requests for your passwords, when it comes to invasive questioning about your religious practices or your activities or associations, detention at the border, how long you could be held. Please keep sending us your questions and visit our website. If you go to aclu.org/airports, you can get some good Know Your Rights materials, and there's also a link to a form you can use to report to us troubling situations you've run into at the border, whether it's airports or a land border. We want to hear about it because we're really committed to pushing back against some of these very expansive claims of authority by the government as they interact with people traveling across the border. Ben asked a question about cloud backups. With cloud backups from a phone or a laptop, could I wipe the device before getting to the border and then restore, the materials on the other side? If I do that, can border agents legally compel me while I'm there at the border to restore that data to the device?
This is a factual scenario we haven't heard about specifically. The question of whether you can be compelled to restore data. As I said at the outset, I think the question of whether you can be forced to turn over a password is clearer for citizens and returning green card holders. If you are a citizen and a green card holder and you are asked to restore data or provide any sort of access to cloud-based accounts, I think you would be justified in refusing to do so and not affirmatively providing evidence that's located somewhere else, because the justification for border searches are the government is searching you to determine admissibility and whether you're carrying contraband. If you are a citizen or returning green card holder, your admissibility question should be settled, certainly for citizens very clear. And, cloud stored data that's on a third-party server is not anything that you are carrying on yourself. It's not in any conceivable or meaningful way contraband that you could be transporting across the border. But this is an untested question. It's certainly an understandable question in light of reports that we've heard that the government is considering asking for social media passwords as a condition of entering the country. The sort of legal status of that for visitors is very different for citizens, and we have not heard of citizens being asked to restore data or provide access to data that's not even being carried on the person.
So Artie asks, if you find yourself being singled out at the border, what can you do there? Is there a number you can call to try to get help? If so, what can you do to try to bolster your position in that moment?
That's a tough question, and that's a dilemma and a problem that many travelers face, because typically you don't have meaningful access to your phone. Even if you do have your phone on your person, the officers will prohibit you from using it. If you do have access to a phone and you feel that you need assistance, then by all means use it, as long as you're not directly disobeying an order from a CBP officer. And you could use it to call, a loved one or a lawyer, somebody who can get assistance for you. But it can also be difficult for that person then to gain access to you in order to render that assistance. So it can be quite difficult to respond meaningfully in that situation proactively. But one thing you can do is assert the rights that you do have, and you can politely assert those rights. You can also ask to speak to a supervisor. And very often we've found that being assertive in a non-confrontational way can be actually quite productive. And if it appears that you're aware or you have a strong sense for your own rights or sort of the limits of the information you're willing to divulge, that making it very clear what those lines are for you can actually help defuse the situation and in some cases get you out of there faster. But the reality is that very often it's a matter of simply waiting until the CBP officers have satisfied themselves that that you can be let go.
So Pepin asks, how do we know what they can do with the data once they search or copy it off of your phone or your laptop? Are there limits on what they can do about it? Do they have policies?
Do you want to take that one?
Sure. Well, there are retention limits for the data that they have that they've either taken from your device or that the notes that they've taken that may describe some of the data on a device. Those retention limits are a little different. It does seem that if they have copied, mirrored your entire drive, that they're supposed to make a determination about whether or not they need to retain that information. They're supposed to do it relatively quickly. And if they don't need to retain that information, they're supposed to get rid of it. It may be different, though. They may have quite longer retention periods for information that they have put into their notes, making observations, not the data itself, but their notes about the data. And it seems, under our reading of some of the relevant authorities, that could be retained for up to 75 years. So that's quite a long period.
So Robert asks, what's the statutory or regulatory authority that the government claims authorizes them to do these searches? And I would add to that, there's the question about the search itself, and then there's some authority that the government has pointed to that they say allows them to force somebody to turn over a password. Can you talk about what the limit of the laws are, and then how that interacts with the Constitution?
Yes. So CBP and ICE are relying on policies.
I should say CBP is Customs and Border Protection, ICE is Immigration and Customs Enforcement, two branches of the Department of Homeland Security that are often collaborating in these areas.
Yes. So there are government policies dating from 2009 where both of these agencies essentially say that as part of their authority to conduct border searches, they can also conduct searches of electronic devices without individualized suspicion. One of the questions that we are seeking answers on is whether these policies are still in effect, whether there's been any change since then, whether there's any more detail about, under what circumstances device searches will happen. But that's what we've seen publicly. There's also a statute that seems to permit customs officers to seek assistance from other people in carrying out their duties. And we've seen some arguments from the government saying that this assistance statute also gives them the authority to compel people to hand over their passwords. This is an interpretation that's never been tested in the courts, and we think it would raise serious constitutional concerns if, in fact, the compelled assistance could be compelled from the very person being searched. Most likely the intent of the statute was to cover assistance by third parties in different circumstances. But that's the state of the government's positions, and we certainly argue that there are constitutional limits on device searches without a warrant and individualized suspicion. And so this government policy is not actually consistent with the Fourth Amendment. But that issue is going to be considered by various courts in the coming months and years. As Nate mentioned, we have filed a friend of the court brief in an appellate court based out of Virginia most recently, where the government has argued that they can do device searches without individualized suspicion, and where we argue that a warrant is required.
So we're here at the ACLU. We're talking about your rights at the border when you have an electronic device that may be subject to a request to search, or you're under questioning by the government. Desiree has a question about how long you can be detained and what you can do about it. And she asks, as a follow-up to something we were discussing earlier, if you are being detained for 4 hours or 6 hours, or longer, and then they let you out. Can you do something about it? What can you do after the fact?
Well, just to say at the outset that under the existing case law regarding border detentions, there's nothing inherently unlawful about detaining someone for up to 4 to 6 hours. In fact, it's sort of leading case on this issue. The plaintiffs in that case were detained for 6 hours, and the court in that case blessed that detention. In some ways, that was dependent on those specific facts, but courts have given a great deal of deference to the government in terms of how long it can hold you. Afterward, you can seek redress in a few ways, none of which are particularly adequate. But there is a program called the Department of Homeland Security Traveler Redress Inquiry Program, and that's available if it appears that you are being repeatedly detained, or if you're subjected to secondary inspection whenever you enter the country, or frequently when you enter the country for reasons that may be related to inclusion on a watch list. Other kinds of indications would include if you frequently subjected to secondary screening by the TSA when you seek to fly. So you can submit a petition under that DHS TRIP program. You can also submit administrative complaints to the DHS components, whichever component CBP or ICE is responsible for the conduct that you're complaining about. There are other ways that are sort of less official. You can always be in touch with your member of Congress. That can actually be quite productive at times. Of course, you can contact us. And failing all that, there's the option of litigation. It can be difficult to bring a lawsuit challenging some of these practices just because of the discretion that officers have at the border. But there are a number of tools that are available, and simply raising these issues and doing so repeatedly and bringing them to the attention of the government can actually be an important step in at least getting them the data and the feedback that they need to begin to respond to them. So it's important to raise them.
Jose asked a question about how to help somebody that you know who's at the border. This relates to something you were talking about earlier, Hugh. Jose has family that's going to be visiting from out of the country and is wondering, if they are subject to extra questioning, extra screening, if they're held for a long time, is there anything he can do to help them in that situation?
I think just education beforehand is very important, and that's why we're holding this event, and making sure that you're aware of what the limits are on the government's conduct in those situations, so that you can confidently assert your rights and establish sort of limits or ground rules, if I may, during those kinds of detentions, and escalating them when you're in the situation to a supervisor if it appears that the conduct is inappropriate. And if there is the option of using a phone to get a hold of someone to seek assistance, then taking that option if necessary. But I think the advanced planning and the awareness ahead of the issue, and of course when it comes to devices, making sure that if there's anything on a device that you simply do not want to be searched, that's not accessible from the device, or that you've taken the steps that Aisha mentioned earlier, encrypting the device, setting a strong password, powering it down, and then prepping yourself for arrival at the border.
So to return to something we talked about earlier, but I think it bears repeating again, Pepin asks, if I'm at the border, can I refuse to unlock that phone? If they, the phone is encrypted, it's password protected, they're demanding for it to be unlocked. Who can refuse, and what circumstances and what recourse do you have in that situation?
Mm-hmm. So the answer to that question does depend on immigration status. If you are a citizen or a returning green card holder, you shouldn't be refused entry to the country for refusing to hand over your password. But the consequence could be that you are detained for longer than you otherwise would have been, and that the government might seize your device and keep it for weeks or months. So the decision in that moment really is up to you. It's a personal decision whether you would rather refuse to hand over your password and potentially have the device seized, or whether you would rather not risk that. For visitors who are here on visas or through visa waiver countries, there is the chance that by refusing to give over a password, you are denied entry to the country. So that's another factor that you should consider. One thing that may be helpful if you are carrying particularly sensitive information that would be protected, let's say, by the attorney-client privilege or a journalist privilege or doctor-patient privilege, you can always try mentioning that to the CBP agent or asking to speak to a supervisor and mentioning that if your device is searched, there's privileged information on it that the government might see. It's always worth trying that. But certainly, citizens and returning green card holders shouldn't be refused entry to the country if they refuse a password.
Well, that brings us to the end of our time here. Thank you all for joining us. Thanks to both of you. If you have more questions about what your rights are at the border, please visit our website. If you go to www.aclu.org/airports, we have Know Your Rights materials. We also have a link where you can report incidents you've experienced at the airport or your loved ones have that we can take another look at. We are doing a lot of work in this area, trying to support people's rights at the border, trying to push back against the very expansive claim of authority that the government has there, and to defend all of our rights under the Constitution. So thanks again. We're here at the ACLU continuing to do our work, and we can't do it without you.